Hey everybody, I'm Rob Freeman and welcome back to Securing the Built Environment. This is episode 152, and in this episode we're going to be talking about a compliance trap that you should be aware of if you are a building owner in New York City who has to comply with Local Law 97, the building decarbonization law. And that law has been in the news lately because they just extended the deadline for reporting, not only for benchmarking for buildings that have to comply with the benchmarking law, but also for Local Law 97, which is basically any building over 25,000 square feet has to comply with the Local Law 97 law to reduce their carbon emissions. And so, in order to comply with this law, most building owners are getting into doing work that is going to reduce their carbon emissions. And that can be any type of construction work related to building envelope, replacing HVAC systems, putting solar on the building itself. There's all sorts of ways and strategies that you can go about reducing your carbon emissions if you're a building owner in New York City and you have to comply with this law. But in the process of doing that, you should also be aware of this issue that can result in raising your costs significantly in the process of complying with this law. And that is Labor Law 240, also known as the Scaffold Law. So the Scaffold Law in New York is a law that in New York City imposes strict liability on not only the contractors, but also the building owners in any claim related to gravity-related injuries. And so this could be somebody falling from heights. It could be somebody getting struck by something that falls on them. And the implications of getting caught up in one of these lawsuits is very significant. It can range from $100,000 to $200,000 for a claim for a minor injury like tissue, small like tissue damage, soft tissue damage, to tens of millions of dollars for something like a wrongful death claim in the event that there was negligence on the job site. And again, the reason that there's a compliance trap with Local Law 97 is that you're going to do some work to make your buildings more efficient in the process of complying with Local Law 97. And that, in almost every case, is going to put you at some risk for being exposed to a Labor Law 240 claim, because really a gravity-related claim is a very broad term. It can mean anything from, falling from like even a curb to somebody trips and they fall. That could be height differential that results in a labor law claim. And what happens in a labor law claim is that a injured employee who works for the general contractor or subcontractor gets injured and they file a workers' compensation claim. And then there's nothing to keep them from also filing a claim against the general contractor, their employer, or the building owner if they believe that there was some negligence involved. And the reason for this is that, again, there's a strict liability associated with Labor Law 240. And so that means that even if the employee was negligent in causing or they contributed to their injury, they can still drag the landlord into this lawsuit, and that can result in a much higher cost of compliance with whatever the work is that you're trying to do for Local Law 97. And so, again, there's a lot of ways that you want to protect yourself from this, but the first way primarily is making sure that you have strong documentation with the right risk transfer language in place with any contractors that are doing the work, verifying with the contractor that you've read through their insurance policy to make sure that they have coverage for what's called an action over claim, and then working with your insurance broker to make sure that you are covered at each step of the way in the process of the work being done for compliance with Local Law 97, and that you don't have any gaps in your insurance coverage with either the work with the general contractor, or if they're hiring a subcontractor to do any work for you, that the subcontractors also have that insurance coverage, and that there are the right endorsements to make sure that you are added as an additional insured on all of the parties that are doing the work's insurance, and that that insurance is in compliance. So below this video, I'll link to an article where I go into more detail about the ins and outs of complying with New York Labor Law 240. And so Local Law 97 is a reality that everybody has to deal with who has a building that's over 25,000 square feet. And there are the nuances to whether you are falling into the requirements for that law. But that's really, when it comes down to it, this is just a cost of doing business today in New York. My contact information is below. I'd love to hear about your projects and how you're handling them. And if I can help, I'd love to do so. So reach out to me at the link below, and I look forward to talking to you. And thanks for watching, and have a great day.